got the Honorable Chief Justice of Karnataka, Shri Justice Prasanna B. Varale, Honorable Justice Sanjeev Hanchate, Honorable Justice P. N. Desai, the Additional Solicitor General of India, Shri M. B. Nargun, all my colleagues in the state government, Additional Advocate Generals, the members of Lahari Foundation, and more importantly, the family members of late Shri P.G.C. Chengappa, distinguished invitees, all the younger students of law. I think Sumana has spoken little more than what I expected. I don't know how much I deserve of that. Before I begin the lecture, it is our duty to pay our salutations and pranams to late Shri P.G.C. Chengappa. The speakers preceding me have given a very vivid picture about him as to how he was just not a lawyer, but he participated and took interest in various activities. He was, I was reading, a General Secretary of the Advocates Association. He was actively associated with Lions Club for Social Work. He organized many lectures which included the great jurist Sri Nani Palkiwala. He participated in many other activities. But I really think it is of some interest if I have to share my personal, very little interaction I had with him. In my very beginning years of my practice, he was the government advocate. I remember arguing a matter before His Lordship Justice Gopala Gowda. The question before the court was as to whether denatured alcohol was fit for human consumption. If it was unfit for human consumption, as you are all aware, it would go outside the session of the state legislature. So the argument I was trying to make before the court was it was unfit for human consumption. I had to labor for 2 days before His Lordship Justice Gopal Gowda. At the end of 2 days, when I sat down, Justice Gopal Gowda looked at Mr. Chengappa and asked him, "What do you say?" All that he said is, "I agree with him." This was the kind of fairness we had. That was an experience I will never forget in my life. That was the kind of fairness he exhibited as a government advocate. And today, I'm very happy that his memory is being carried on by Lahari Foundation and a very able and eminent daughter in Anu Chengappa. Lahari Foundation itself, I must congratulate them for the kind of activities they have undertaken. I was just thinking of what Justice Hidayatullah says in his book, A Judge's Mislead. He says a lawyer with a knowledge merely of law is just like a mechanic. But an advocate who trains himself in the field of art, literature, music becomes an artist. So I think for all of us as lawyers, such kind of organizations who not only engage you in pure learning of law, but engage you in other activities are necessary to be an accomplished lawyer. Of course, on today's topic, Constitution of India, a transformative charter. Before I say anything on that, I must also add a small caveat. When Ms. Suman Valiga came to my chamber and asked me to deliver a lecture, I said lectures are delivered by accomplished authors, men who have achieved something, and I am a student of law. But she insisted. But then I thought, in my experience as Additional Solicitor General for the Government of India and Advocate General now, my own experiences I must share to you as to how I have seen Constitution work. But I am very conscious of my limitations, having regard particularly of the fact that the audience not only consists of some senior advocates and distinguished men, but it consists of the Honorable Chief Justice and the Honorable Judges who themselves are embodiment of the great knowledge of constitutional law. So with their permission and salutations to them, I may share my thoughts on this subject. Constitution of India, a transformative charter. The reason why we chose the topic was, if you are to ask a student of law who is studying in first year law or second year, what does constitution mean to you? He would possibly say, constitution contains 395 articles, 12 schedules, 3 appendices, and it has undergone 104 amendments. That is what the constitution is for me. But over a period of time, now I understand what the constitution. As I see, constitution is not mere a textual document, a document which arranges the power between the different authorities. It is not a document merely which gives rights or obligations. It is something more. According to me, it is an aspirational charter given by the founding fathers. When they wrote that famous preamble, they spoke of justice, political, economic, and social. They spoke of liberty of thought, expression, belief, and faith. They spoke of fraternity. They spoke of assuring unity or integrity of the nation. They spoke of dignity of the individual. They all spoke these things because this was their aspirations. The country which had freed itself from 200 years of British imperialism were deprived of these things. Therefore, what they were deprived, what the generations before was deprived, they wanted to give that to this countrymen, and therefore I say the constitution is an aspirational document of founding fathers. The constitution is also a set of ideas, ideals, and values on which this great nation is built up. The constitution is also a bridge between the past and the future. The constitution is not mere a textual document. There is so much into it. But then, no generation can be static. No nation can be static. So cannot be the constitution. Therefore, the present topic is as to how the constitution has changed over the last 72 years. Therefore, we say constitution a transformative charter. How it has transformed. Now, I must bring to the notice of this very august audience that constitution has affected individuals, institutions, groups, authorities, and a nation as a whole. It has affected in different fields. But for the last 72 years, how it has transformed the lives of individuals, how it has transformed the institutions and various authorities is a story by itself. For the purpose of the topic, I thought it would be interesting to most of you to see as to how the constitution has transformed itself into 4 distinct areas. And the areas which we can divide are, firstly, transformation of the constitution relating to agrarian reforms. Secondly, transformation of constitutions relating to affirmative action. Transformation of the constitutions relating to dignity of the individual. And lastly, transformation in strengthening political democracy in this country. Now, when I speak of how the constitution has transformed itself into agrarian reforms, we could see that at the beginning of the commencement of the constitution, in 1950, we must all remember 2 articles. Article 19(1)(f), which was the fundamental right to property, and the unamended Article 31 as it stood then, which related to compulsory acquisition of property. Now, it was in this background you could see how the concept of agrarian reforms was ushered in. Now, I was reading when I was preparing for this. Immediately after our independence, one of the primary tasks before our legislatures was two very bad legacies which we have inherited from the British and the Mughal emperors. One was the last zamindari system, jagirdari system, Mahitwari system and Rayatwari system. Fragmentation of holdings were not there. Large tracts of land were held by few individuals. This resulted in the first task of bringing what we call as land reforms or agrarian reforms. It was in this background, and ironically, it was the state legislatures who initially ushered in these land reforms. To begin with, it was Bihar land reforms. Maharashtra took the lead. Uttar Pradesh, Kerala, and also Madras presidency. All of them brought in a lot of legislations by which tenures were abolished, rights were modified, and lands were given to the tillers. Now, this legislation's 19(1)(f) is there, right to property as a fundamental right. Immediately, all of them were called into question before various high courts. Patna High Court immediately struck down these legislation on the ground that it violates fundamental rights, it violates the fundamental right to property, it violates Article 14, etc. Also, it violates Article 31. Similarly, we had most of these legislations being struck down. Now, this was the first challenge before the Parliament. We have said social justice in our preamble, we have said liberty, we have said equality, but if several of the lands are going to be concentrated in few hands and we don't bring in social justice, how do we work? Therefore, we had the very first amendment to the Constitution in the year 1951, piloted by Dr. Ambedkar. The first amendment, of course, also had different chapters, but for the purposes of agrarian relationship, two articles requires to be mentioned, Article 31A and Article 31B. Article 31A said, notwithstanding anything contained in any of the fundamental rights, any modification of tenure rights, etc., shall not be called into question before any court. I am only bringing you the gist of the amendment, not Article 31B, more or less, was a consequence of 31A. For the first time, they introduced the concept of 9th schedule and said, all those acts or legislations which are inserted in 9th schedule shall never to have been void or will never be called into question. So, in goes all these legislations which were struck down by the various courts into 9th schedule, and they gave a deeming effect retrospectively, saying that they'll never be void. Therefore, protection was given. This was you could now see the first step toward transformation. The constant interaction between the courts and the legislature is a story of transformation. Now, Article 31A protected any of the land legislation if there was modification of rights or tenures. This was immediately called into question before the Honorable Supreme Court, as Lordship was mentioning, in Shankari Prasad's case. Now, this is the beginning of the series of judgment we are all aware, relating to 31 and 19. Now, Shankari Prasad, though the law relating to 31 and 31B was called into question, the arguments which were advanced was immediately went to some other article, that is Article 368. We are speaking of transformation, therefore Article 368 becomes very interesting and important, because 368 is the only article in the Constitution which speaks of change, the power of the Parliament to amend the Constitution, or rather change the Constitution. Now, the entire discussion in Shankari Prasad Dev's case is about Article 368. It was argued very passionately, saying that The Parliament could not have tinkered and touched upon the fundamental rights. It could not have nullified judgments of the courts, etc. And the question before the Honorable Supreme Court was, what is the scope and power of the Parliament in amending the Constitution itself under Article 368? Number two, as to whether law as contemplated under Article 368 would include law under Article 13, subclause 2. For my younger friends, students of law, I must just share so that they understand. 13.2 is any law made by the Parliament, if it does not conform to Part 3, is liable to be declared as void. Now the question was, and if 368, if any law was made and it did not run, it ran counter to Part 3, it was liable to be declared as void. That was the question. The bench was headed by Honorable Chief Justice M.H. Kania. They by majority held Article 368 is a power of the Parliament which can amend the fundamental rights also. Secondly, they said, when you exercise the power of amendment under Article 368, you do not exercise the ordinary legislative power, but it is the power of the constituent power of the Parliament. It's much higher than the legislative power. With these two conclusions, they upheld the First Amendment to the Constitution. Imagine if Shankari Prasad had remained and First Amendment had remained. It would have given the Parliament an absolute power to amend any part of the Constitution, including fundamental rights, and suspend the fundamental rights. Imagine if Shankari Prasad had remained. They could have, Parliament could have said that there is something called a constituent power and we can abrogate the Constitution itself. But then, as the story goes, it did not remain so. But somewhere in the year 1961, almost 10 years this position prevailed. In Sajjan Singh's case, the 17th Amendment to the Constitution was called into question. Now, the 17th Amendment as such was of not great significance, except that by this time, another 21 acts were inserted into 9th schedule. So this had become a pattern. After upholding 31B, every state legislature used to go and simply insert it in 9th schedule. Therefore, out it goes from the jurisdiction of the courts under 226 and 32. Now, Sajjan Singh's case, interestingly, sought reconsideration of Shankari Prasad, and the bench at that point of time reiterated the position of Shankari Prasad. Except that Chief Justice Hidayatullah and Justice Mudolkar strongly dissented with the view of Shankari Prasad. And Hidayatullah very famously said that Part 3 is not a plaything of a special majority. And Mudolkar said, I can never agree with the principles laid down when Shankari Prasad, but it was Gajendra Gadkar who said, fundamental rights are not permanent and inviolate. Shankari Prasad was correctly decided, fundamental rights can be interfered or tinkered with even under Article 368. So, we have Shankari Prasad, First Amendment, 17th Amendment, Sajjan Singh reiterating, position almost settled. That brings to what we now call as the pre-fundamental rights case, that is Golaknath's, in the year 1967, bench headed by Chief Justice Koka Subbarao. Now, 17th Amendment is again very interesting. It was about insertion of another 25 state legislation into 9th schedule. But 17th Amendment also became necessary because some of the high courts, particularly the Kerala High Court, had held the original protection given to this land reforms legislation was only modification of estates and tenures. But the Kerala High Court took the view, Jagirs, Mohafis, etc. cannot be considered as estates. Therefore, an amendment was brought about. They said estate includes Jagirs, Mohafis, etc. Therefore, the position stood restored. Now, Chief Justice Subbarao was very clear. He said there is nothing like a paramount power. There is nothing like a constituent power. And he explained that the power to amend the constitution is not actually Article 368. He said it is only a procedure to amend the parliament, procedure to amend the constitution. The power to amend the constitution actually lies under Article 245, entry 97 of List 1. That is a source of power relating to legislation. His first principle therefore was 368 is not a power at all to amend the constitution. Power to amend the constitution lies in 245, entry 97. Therefore, you have to judge your power only with reference to that. The concept, the question of any law under Article 13 subclause 2 would include even amendment to the constitution would include law. Therefore, if you violate part 3, out goes the amendment, and therefore you cannot touch the fundamental rights. Hidayatullah, of course, specifically overruled Shankari Prasad, and this became the position of law. Now, it was in the year 1967, but then we had, if this position had continued, possibly things would have settled. But we then had 24th, 25th and 29th Amendment to the Constitution. This was possibly the beginning of the days towards emergency. The 24th Amendment now said and the amended Article 368 itself, saying specifically that nothing in Article 13 will apply to Article 368. That was 24th Amendment. 25th Amendment took away the concept of compensation itself under Article 31. They said you don't have to pay compensation if you are to take property of a person. All that you have to pay is an amount, and what shall be that amount will be determined by the legislature. The interrelation between deprivation of the property, etc. It also had several other amendments. 29th Amendment was again a formal amendment. By this time we had 9th schedule being packed with almost 72 legislations, and 29th Amendment was all about that. Now, this was the background on which Keshavananda Bharati was set up. There are a number of discussions. I am sure you heard about Keshavananda Bharati. I will be as brief as possible because time is running out. Chief Justice Sikri, Shahalat and Grover, Hegde and Mukherjee, Justice Jagan Mohan Reddy, Justice Untwalia, Justice Vaidilingam, Justice Jagan Mohan Reddy, Justice Palekar, and never to forget Justice Khanna constituted the bench. The lead judgment first comes from Justice Sikri, wherein he says fundamental rights can be amended. He says the concept of Article 368 not being a source of power becomes academic because 368 itself is amended, where Parliament itself says we have the power to amend the Constitution itself. And then, of course, for the first time, he spoke of Constitution being a social document, Constitution being an organic document. But the golden feature in the majority judgments, which includes that of Justice Khanna, is about the argument advanced by Mr. Palkiwala, which now most of you know is about basic principles, basic structure, essential features. The golden principle in all this, they say, the Parliament has the power to amend the Constitution. It can amend Part 3 as well, so long as you do not touch the basic structure of the Constitution, Honorable Chief Justice in his very introductory remarks was mentioning to some of them. Palkewala gives a list in the Keshavananda Bharati. Justice Sikri lists something, lists few. Republican form of government, supremacy of the constitution, separation of powers, doctrine of checks and balances, democratic way of government, periodical elections, etc. Several of them. But then they say this is not exhaustive but illustrative in nature. As and when time comes, we will see that these features are developed further. Keshavananda Bharati, I will leave it at that. So the conclusion was, Parliament had the power to amend. Part 3 can be amended so long as the essential features are not affected, which for all purposes secured the citizenry of a future arbitrary government. I will conclude it by saying that. No despotic or an arbitrary government could have amended the constitution to take away the fundamental features after having listed out the fundamental. And this was the transformation which we undertook from 1950 to 1973. The last of the judgment in this series, I must mention, is that of Minerva Mills case. I wish they had accepted this position in Keshavananda Bharati and left it at that. No, it was not so. It was an incorrigible government who thought it, no, we will go back once again. And they once again amended Article 368 and said that this is not constituent power. They actually mentioned this is the constituent power. We are now exercising a constituent power, and therefore any challenge to this will not be available. In fact, they said any amendment made under Article 368 shall not be called into question before any court. They amended 31C and said, if any law is made invoking the principle that this law is made for the implementation of directive principles of state policy, it shall not be called into question. Virtually taking away the jurisdiction under 226 and 32. As I said, if they had accepted Keshavananda principle, we couldn't have. This led to the last confrontation. Again, this time Chief Justice Chandrachud, as he then was, Justice Bhagawati's 6 judges writing one judgment headed by Chief Justice Chandrachud. The other separate judgment is by Justice Bhagawati. Mr. Palkewala's very brilliant argument again, 42nd Amendment to the Constitution. They read down 39C and said that this is something which affects the power of judicial review, therefore out it goes. Therefore, the last, of course, I was thinking this was the last, but I must mention when I could hear the Honorable Chief Justice speak of Ayar Coelho. The question is, therefore, what is the scope of the power of High Court and Supreme Court if an act goes into Part 9 schedule? That stands now settled in Coelho's case, where they say, if any legislation touches upon the basic structure of the Constitution after 1973, that is the cut-off date of Keshavananda Bharati, it can certainly be looked into by the court under 226 and 32, and it cannot be tested like an ordinary legislation. That is the position of law. So after having seen these agrarian reforms, what is that transformation the Constitution underwent? As I said, and I'll repeat it. Transformation of the Constitution is all about a constant interaction between the legislature and the courts. And you have seen how Amendment 1, court upheld, striking down for up to 44th Amendment. You can imagine. Number 1, fundamental rights to property was no longer a fundamental right at the end of it, repealed by 44th Amendment. Concept of essential features of the Constitution, fundamental feature, basic features was introduced, which for all purposes would remain for all generations to come. Agrarian reforms came to be accepted by the courts as well. It would possibly shock anybody's conscience if 1950, most of these legislations being struck down by the court, today you see accepted, reduced, and lastly The word amount, compensation, Supreme Court interpreted it by saying compensation should have a rational nexus to the value of the property. So this is how the reconciliation took place between the courts and the legislature, and we have this position. It may not be the last word still spoken. We may have different situations. If we have seen this, of course, now we have Article 19(1)(f) transformed into 300 capital A. We have right acquisition laws have changed. Right to Fair Compensation Act has come. It has different connotations, etc. For the purpose of present discussion, I will leave that. The second area which we must see where transformation took place is the area of affirmative action. Affirmative action, protective discrimination, positive discrimination, I will say it is social justice, is a subject or is an area where you can see the Constitution constantly undergo up to 2 months ago when the EWS judgment was delivered. Now, possibly one of the most passionate subjects, passionate chapters in the Constitution is about affirmative action. Our country at the time of independence and soon thereafter had a lot of discrimination based on caste, gender, etc. So one of the gigantic tasks before our constitutional makers was to usher in equality, usher in social justice. And how did they do it? They did it by introduction of Article 15. When they said, no person shall be discriminated only on the basis of caste, sex, place of birth, etc. Residence. 15(3), interestingly, for all of you to know, they said state can make advancement for women and children. They only thought women and children will be the deprived class. Can take special measures. That means you can discriminate. That is positive discrimination. They came to public employment. They felt members should not be discriminated in public employment on the basis of caste. Therefore, they introduced the concept of equality in Article 16. Of course, this was preceded by Article 14, where they said there shall be equality of laws and equal protection of laws. Last article possible is Article 17, whereby a constitutional injunction, they said, abolition of untouchability. These 4 articles we could see. We all thought we were moving towards social justice. Look at this, 15 says, no person shall be discriminated only on the basis of caste. The Madras government reserved certain seats in favor of non-Brahmins, members belonging to scheduled caste, scheduled tribe and backward classes. Now, Srimati, very famous, Champaka Dorai Rajan, you must be all aware, filed a writ petition before the High Court and matter went up to Supreme. Her contention was, I have been deprived of my equal opportunity to participate because I belong to a particular caste. Now, this 15 one, according to me, was actually meant to give a protective discrimination to this, but here the Constitution was turned on its head by this argument. So, as a matter of fact, the Honorable Supreme Court accepted that argument, struck down the Madras order, which was termed as a communal geo. It was known as a communal government order because communities were mentioned. And this led to Dr. Babasaheb Bhimrao Ambedkar introducing, as I was mentioning, first amendment to the Constitution, which brought in 31A, 31B. But this was one of them. When he included for the first time, most of you, 15(4). When the first, therefore, the original protective discrimination in favor of scheduled caste, scheduled tribe and backward classes was by way of an amendment as a reaction to the Supreme Court judgment in Champaka Dorai Rajam, where 15(4) now says, the above provision shall not deprive the state of making advancement or reservations or taking such special provisions. It's actually, the word is special provisions, for the purposes of person belonging to backward classes, scheduled caste and scheduled tribes. You could again see the transformation here. 16 was always there, 16.4 was always there. And we always had a reservation in employment. But what was the extent or amount of reservation was not known. I may bring to the notice of the Honorable Chief Justice, he must be aware of it. Karnataka was possibly one of the forefront states or princely states in making affirmative actions. The then king of Mysore state, Sri Nalvadi Krishna Rajwadiyar, had constituted Chief Justice Miller to go into this aspect, and it was in the year 1931 reservations were given in the state of Mysore. That continued, and in 1961 it resulted in a reservation to the extent of 68%. Now, this is the state set up for M.R. Balaji versus state of Mysore. Nagangowda committee was appointed. Nagangowda recommended 68%, matter went up to Supreme Court. The question before the Honorable Supreme Court was whether this concept of reservation to the extent of 68 to 69% was reasonable, can be held constitutionally valid, etc. Two principles their lordships elucidated. One was, they said, caste can never be the sole factor for making reservation. And Nagangowda committee was based solely on caste. It said that cannot be the only factor. Second principle was, for the first time they introduced the concept of 50%. If you go through the judgment, you will never see why they got this 50%. But they felt possibly 50% of the action should be protected, 50% should be protected. They said anything beyond 50% is liable to be declared as unreasonable and arbitrary. And Nagangowda committee came to be set aside, and all states were confined to reserve or do affirmative action within this concept of 50%. After that, of course, we have had a lot of judgments on this. I will not refer many of them because we will straight away go to Indira Swami. S.V. Joshi's case was one, again arising from Karnataka, where 65% of reservation was affirmed by the Honorable Supreme Court. Matter was remitted back to the to the government. But it is Indira Sawhney which again throws open different concepts on affirmative action, and you could see the transformation which takes place. Indira Sawhney, interestingly, the matter arises out of a very old report submitted by Sri Mandal to the Government of India in the year, somewhere in the year 1979-80, wherein he had recommended that reservation to the other backward classes must be provided to the extent of 27%. Accepted by Mr. V.P. Singh when he was the Prime Minister in the year 1990, we are all aware, it led to a social backlash. Matter reached up to Supreme Court, 9 judges bench. The question before the, of course, Honorable Supreme Court has formulated number of issues fell for its consideration. First thing they say is, they to an extent take a different view from M.R. Balaji. They say caste can be the sole factor. And they say over centuries of our period, caste has been the sole factor for discrimination. So if caste is made the foundation of protective discrimination, that is permissible. 50% of reservation, they accept it, but make an exception in para 810, they say, though this is 50% is a rule, but that is not a firm rule, there could be exceptional circumstances. A small window to breach 50% is given in Indira Sawhney. I am using the word breach, but I will say ultimately cross 50%. Of course, the judgment, Justice Thoman, Justice B.P. Jeevan Reddy, Justice Ratnavelu Pandian, Justice Kuldeep Singh, all of them have given different judgments. But interestingly, one of the honorable judges says these are not matters which the courts were expected to decide. These were matters which the Parliament was expected to decide. We are asked to decide, so we are going to do it. So, Justice Pandian in his judgment very passionately speaks of equality. as to how concept of social justice which is there in the preamble has to be given its reality, etc. Indira Sohani is followed for a long period of time. As I was saying, one small interlude I will say as to how again the interaction between the courts and the parliament took place was in Indira Sohani. They also said, very interestingly, reservation is only at the first point and not for promotions. So no reservation in promotions, it is only at the initial. Then you had the parliament react once again, Article 16 for promotion, reservation in promotion as a fundamental right. Tested in Nagaraja, affirmed. This is the set. Now we come to the judgment arising from His Lordship's home state, that is Jayashree Patil versus State of Maharashtra. Interesting case. I had a personal experience in appearing in that matter when it was referred to Constitution Bench, because Jayashree Patil, when it was posted initially before His Lordship Justice Nageshwar Rao stayed the judgment as well as the legislation, but then referred it to a larger bench. The reason was passionate argument saying that the concept of 50% should be revisited. Indira Sohani itself requires to be revisited, referred to a larger bench, because Maharashtra had crossed 50% to the extent of 62%. The matter was before a 5-judge bench. And Jayashree Patil's case, of course, the legislation was struck down on the ground that there was no quantifiable data. Insofar as 50% is concerned, they took a slightly different view, or rather I will say expanded Indira Sohani principle, saying that yes, it is just not far-flung areas for which reservation needs to be given. There could be several cases in which you can cross the limit of 50%. If these were the principles, we had, in fact, I must bring to the notice of this very august audience, we had specifically on behalf of State of Karnataka argued before the court that please do not treat this 50% as a golden rule, because by that time 15(5) and 16(5) were amended. A reservation based on economic resources was done. 371J was amended, by which 8% of reservation was given. Therefore, by constitutional intervention itself, 50% had crossed. Anyway, their lordships did not adhere to these issues. Now we have, last of the judgments is amendment to 15(5), as I was saying, 16(6), where the first time they say, they change the very foundation of reservation, affirmative section, says poverty, economic backwardness can be a factor for affirmative action. Now this is the policy of the government. Economic backwardness can be the basis of affirmative action. Tested before the Honorable Supreme Court, leading judgment by Justice Dineshwari, Justice Bela Trivedi and Honorable Justice Pardiwala, dissenting judgment by R.S. Bhatt, seconded by Justice Lalit. But insofar as 50% is concerned, His Lordship Justice Dinesh Maheshwari says, this is not an inflexible and inviolable rule. There could be cases where you can cross 50%. And therefore, reservation, even if it is to cross 50%, can be upheld. Justice Ravindra Bhatt, in fact, also seems to agree on this concept, but differed it on different issues. Anyway, it has its own contour. Some of the matters may be sub judice. I will not go much. But the point which I want to make before the very august audience is, you could see the transformation again in matters relating to affirmative action. The concept of bringing people who were left behind the mainstream, initially curtailed by the Supreme Court to 50%, now is no longer required to be 50%. Number one, social and educational backwardness are not the sole criteria for the purposes of making affirmative action. It could be historical, social and educational backwardness. It could be economic backwardness. And most interestingly, Krishnamurthy's case learned friend Mr. Dhyan is here, he is appearing in those matters. Political backwardness can be a ground to make reservation, is what the Honorable Supreme Court now says in Krishnamurthy's case. So that is the transformation the Constitution has undergone from the time when we were reluctant to provide reservations, which was termed, colored as communal geo set down. Today, reservations are not considered an exception to merit, but they are considered as the main bulwark for achieving absolute equality. Affirmative action is to correct historical injustice. And in Indira Sahani, Chief Justice Pandian, speaking on merit, says, what merit is it if we leave out large sections of the society from the main street? What is the merit? What is the definition of a merit itself? So this is the change which the Constitution underwent insofar as affirmative action is concerned. As I was saying, now we have political backwardness. I may bring to the notice of all of you. Now the Honorable Supreme Court in Krishnamurthy's case says, for making reservation on political officers, it is not social and educational backwardness, but you have to study political backwardness as well. We could possibly never think in the year 1950 that we could go to this, this is the way. We could never think economic backwardness. Though I must say, in Indira Sahani specifically recognized that concept of creamy layer was recognized. Before I close this chapter, I have to say something which I am always inspired of whenever I speak of affirmative action or equality. If you are to see the book of Sirvai on Article 14, the very first chapter he quotes the very famous speech of Abraham Lincoln in Gettysburg Address. And that has always inspired me. He says, 40 years and 7 scores ago, we bought on this land a nation conceived in liberty, but dedicated to the thought that all men are equal. And that is what is the foundation of Article 14, 15, 16 and 17. One of the greatest service which possibly we could see or we could pay to our founding fathers is if we are to achieve social justice. Therefore, I will end this by saying that transformative constitutional insofar as affirmative action is about, to begin with, when it was social exclusion to social inclusion. The third subject, of course, is of how the Honorable Supreme Court has interpreted and empowered individual dignity. A.K. Gopalan, where 1951, where right to life was considered merely a right to life, nothing more, nothing less. And if by a procedure established, if you could deprive that person, that was justified. We have travelled a long way from A.K. Gopalan to Puttaswamy. But it was in Maneka Gandhi's case, which forms the paradigm shift insofar as individual empowerment is concerned. I am now talking of citizen empowerment. Individual empowerment, emancipation of rights, expansion of rights, as to how the Constitution has, and the Parliament and the courts have constantly endeavored themselves towards this direction. Maneka Gandhi, most of you are aware of the facts, but the position of law enunciated is very interesting. They said the procedure established by law, as it covers under Article 21, is nearly not an established law, but the law must be fair, non-arbitrary, and must be reasonable. Look at the interpretation paid by His Lordship Justice Chandrachud. It also said, for the first time, took a different view from Gopalan and Bachchan Singh and said, all fundamental rights cannot be considered as individual silos, but they must be read together. There cannot be compartmentalization of fundamental rights. It's a great paradigm shift. It brought about a new era of rights under Article 21, Maneka Gandhi. After that, of course, we have had a number of judgments. I was speaking to one of the professors of law when he said, sir, Article 21 has been interpreted to have 21 more rights by the Honorable Supreme Court. Right to shelter, right to livelihood. Olga Teles, right to a reasonable health care, right to legal services, and 21 are there. All these are transformation which the courts and the parliament undertook, and therefore we had also Article 21A, right to free education, which I possibly never thought of at the beginning of the constitution. That's how we have progressed. Right to education under Article 21, capital A, has been made as is a special fundamental right up to the age of 16 years. Individual empowerment, we have gone further ahead and recognized the third gender. Would never think in the year 1950 in Navtej, Johars and National Legal Services Authorities, recognizing them as third gender, recognizing them as a human being for the purpose of enforcement of fundamental rights. There is no end. Yesterday I was part of the Constitution bench in Jallikattu. The argument now is even animals are interested for rights under Article 21. The jury is still at large. We will see how the law develops. But what is important is the last of the judgments, which according to me is one of the most brilliant judgments under the scheme of the Constitution, is right to privacy. Also known as Puttaswamy's case, one of the most brilliant analysis of the constitutional law by His Lordship Justice Dhananjay Chandrachud. And it is there he says very famously, our preamble thinks of liberty. There cannot be liberty without dignity. There cannot be dignity without privacy. Therefore, read privacy under Article 21. But what is privacy? What is privacy? Spatial privacy, partial privacy. What are the kinds of privacy he describes? He says the center or the fulcrum of our constitution is individual dignity, and you cannot practice dignity, you cannot exercise your liberty if there is no privacy. I think these are all matters, these are all judgments which have gone long way in empowering our citizens and individuals in the scheme of the constitution. It overruled Kharak Singh, etc., and therefore we have come to an end insofar as this empowerment of individual dignities is concerned. It's constantly evolving law. The last of the tranches which I will deal insofar as transformation is concerned, of course, there are a number of topics. The last one is and I will be as brief as possible, is about strengthening of political democracy. It is said that mere democracy is not sufficient, mere political democracy is not sufficient. You must have a democracy which is actually functional. So when you see at the inception of the constitution, the concept of democracy was, of course, by periodical elections, etc., but the concept of universal adult franchise was there. Every person, irrespective of the caste, was entitled to cast his vote. That was the foundation. In fact, that forms part of the preamble as well. But the transformation which has taken place now is the concept of local self-government, 73rd Amendment and 74th Amendment. Again, a huge shift, recognizing Grama Panchayats power to the lowest strata and being recognized under the Constitution. We had intrusions, no election to the post of a prime minister could be called into question, struck down by the courts, saying that all are equal under the democratic system. Periodical elections bound to be held. A creation of an independent election commission. But when Parliament was confronted of a slightly I won't use the word slightly out of bounds election commissioner, it created a multi-member election commission. Again, a transformation. Therefore, strengthening of political democracy, Supreme Court reading the Representation of People Act, asking the candidates to declare their criminal antecedents, etc. These are all matters where we could see the huge transformation which the nation has undergone in strengthening political democracy, again by legislative intervention and by judgments of various courts. Of Of course, there could a discourse on constitution can never end. It could possibly go on and on, but time demands that we end. But when I chose this topic, I had something in my mind. The fulcrum of my topic was, I felt the concept of transformative constitutionalism. When I studied transformative constitutionalism, what appealed to me was a very interesting feature as to when the three great organs under the constitution, judiciary, legislative and executive, can they all come together for something which is very common? But what stares at our face is the very concept of independence of judiciary, doctrine of powers and doctrine of separation of powers and doctrine of checks and balances. But keeping in these things strong, keeping these things intact, can all these three organs come together? And that seems to be the recognition some of the Western jurisprudence seems to now say. And we had several examples in this. And as an advocate general, to the surprise of many of you, you may be seeing this concept of I have seen this transformative constitutionalism actually at work. Most of the judgments when delivered by the courts, the first reaction of the executive, I will say, is more of deference than deference. That is the first reaction is, we have made the law, or this is our action, this is what the courts have said, they are correct. This is what we will implement, unless a different view is taken for other reasons. This is where transformative constitutionalism is there. I am not happy to see legislations which begin by saying, notwithstanding anything contained in any judgment or law, unless this becomes necessary. These are things which we should avoid, and I have honestly felt and seen, particularly during COVID period. Mr. Nargund is there, he used to appear for the central government, I used to appear for the state government. The judiciary, legislature and executive all came together for the purpose of a common good. This is the, I will say, the greatest tribute we could possibly pay to our constitutional makers. Therefore, what is etched in my memory, and I will end by this by saying only this much, is when I begin this idea of what could be the area of convergence, I would hit a roadblock. I did not know what to say. Where is that these areas could come? But I found the answer in none other than by very excellent speech delivered by His Excellency, the President of India, on the Constitutional Day. When she said, doctrine of checks and balance तो ठीक है, कहीं ना कहीं जनसाधारण के लिए, जनता के लिए आप सब लोगों को एक साथ में आना चाहिए. And there cannot be a better statement by the first citizen of the state, of the country. I am grateful that I have been given an occasion to share my thoughts today. I hope and pray that the memory of Mr. P.G.C. Sangappa is kept alive by many more such lectures. I am particularly grateful to the Honorable Chief Justice, who has had the patience to, after a long day of judicial work and a long week of judicial work, to sit with us and hear me. Sir, we are very, very happy and grateful that you are in our midst. I must thank each one of you for giving me a very patient hearing. Wishing each one of you all the very best. Thank you.
Sir, thank you for taking us through this journey, sir, beautiful journey. Your humility is always astonishing, sir. Being such an accomplished person, calling yourself a student of law should in itself be a lesson to many of us. The ease in which you handled the subject today, the manner in which you kept the entire audience on your side, not only you held them with your words, you made them sway to your words, sir, substantiates why most of us, dread the day you oppose us in courts. Thank you, sir.